Can we start?
So, the impeachment court did not grant you to testify the Vice President as Vice President of PAL per se to the article of impeachment theory. Any reaction on that, sir?
I think we've been fairly consistent. Ano po? Ang posisyon namin ay pare-pareho mula ng simula na yung pagpipresenta po ng Philippine Airlines.
Baka magdagdag lang. Nakita natin dito na patuloy na sinisikap ng Senate Impeachment Court na gawing maayos at gawing matuwid yung paglilitis natin. No? Sapagkat lagi ho namin sinasabi, napakadaling magbintang, napakadaling magbato ng mga issues sa isang tao. Ngunit dapat patunayan mo ito. Ngayon, ano ba ang ginawa nila dito? Maglaban kay Chief Justice. Ngunit dito po sa testigo nila, meron po silang panibagong bintang na ilalabas na hindi nila nilatag doon sa verified complaint nila. So makikita nyo natin, kung ang tinatarget ho nila yung bullseye, hindi nila kayang targetin yung bullseye, titirahin nyo nila yung nandun sa gilid. No? O kaya yun nasa kaliwa, nasa kanan. Hindi nyo tayo po pwedeng ganun. Hindi nyo tayo po pwedeng bumato at kung sino man ang tamaan, pupuluntos po tayo. Ano? At maganda ho, at ito'y nakita ng Senate Impeachment Court sa pangunguna ng presiding officer sapagkat hindi na hinayaan na patuloy na sirain ang reputasyon ng akusado dito sa kaso natin ito.
So, di ba may pending pa ho yung inyong motion para i-quash yung subpoena doon sa PAL officers? Tingin nyo yun na yun?
Palagi ko ito na yung resolution kasi nga kung maalala ninyo, bago nagsimula nitong witness from PAL, sinabi ni Justice Cuevas na meron yung subpoena para dito. At sinabi niya yung basis, yun nga, immaterial, irrelevant. At nakita natin na ito na ata yung naging ruling ng impeachment court tungkol dito sa motion to quash.
Kanina bago dumating yung opening pa lang kay Congressman Pariñas, binanggit na ni JPE na magulo yung inyong article. Yung article 2 nyo pa lang, kaya tayo tumatagal.
Po yan ang presiding officer. Kami naman po sa depensa, meron din po kaming obserbasyon. At patuloy po tuwing kami tinatanong nyo at tuwing meron talagang mga defective na o may mga kakulangan itong verified complaint. In fact, sa umpisa pa lang namin itong mga fatal defects dito.
So far, we have seen administrative issues come up here on day 21. First, the prosecution presented Philippine Airlines Vice President of Sales Enrique Javier in their attempt to prove that special privileges were given to Chief Justice Renata Corona, while the FASAP versus PAL case was still pending. However, presiding officer Juan Ponce Enrile denied that Javier could testify, agreeing with the defense that his testimony is irrelevant because there was no mention of special privileges or special benefits, or travel benefits, that were included in Article 3. Now, despite claims of private prosecutor Marlon Manuel that his testimonies would help prove Corona's partiality in this flip-flop of the Supreme Court's decision on this PAL case, the witness was discharged. Now, we also saw Assistant Manager of Bank of the Philippine Islands, Ayala Branch, Mara Arcila, who submitted the monthly statements of Corona in his checking account with BPI, as requested by the senator judges. The prosecution left Article 2 with reservations on the temporary restraining order issued by the Supreme Court on the foreign accounts of Chief Justice Renato Corona and the 8 additional accounts of Corona and PS Bank that has not yet been marked. There are also talks in the Senate here about tweets that are reportedly from the Twitter account of Defense Counsel Attorney Jude Roy, but in a text message to Rappler, Roy has denied these claims, saying this is just black propaganda against the defense. Now, earlier we also heard Cuevas raised concerns about senator judges speaking for more than 2 minutes, but that was just a minor concern. His major concern was that the defense and prosecution should be able to object to the questions of senator judges. Otherwise, he said the M word that a lot of people were surprised to hear again, which is a mistrial. Cuevas again raised the issue that a mistrial is possible if these rules are not followed. Enrile says they will discuss this issue at caucus. Meanwhile, the defense counsels of Chief Justice Renato Corona, the defense spokespersons are having a press conference. Let's hear what they have to say.
So kaya po ngayon, hanggang ngayon is usapin pa ito. Kung ba yung mga dokumento na in-identify ng ating PS Bank President is ebidensya nila. So yan po ang ating kalagayan sa mga panahon ngayon.
Sakaling approve ba ng impeachment court, may adapt yun, na magagawa po ba kayo?
Okay. Doon tayo pa rin pupunta. Siyempre, may authority sa buong proseso nito ang impeachment court. Pero nga naniniwala kami na isa sa ayos ng impeachment court ang procedure na ayon sa batas. In fact, nakikita naman natin kung saan na sila tumutungo ngayon eh. Ako po ay umaasa na hindi po nila i-allow yon unless sasabihin ng prosecution, o sige, lahat ng testimonya tanggapin ko. Hindi kasi pwede portions lang eh. Kaya ang tanong sila, tanggapin nyo ba lahat? Kung tanggapin naman lahat, wala ko kaming problema doon eh. Okay. Opo. Ibig sabihin, even the good and the bad. Ganun po yan. Hindi pa pwedeng proportionin mo lang yung gusto mong kuhanin at you will adapt those portion that you want and then yung sa tingin mo ayaw mo, i-reject mo. Hindi po pwede yun.
Sir, nabanggit ni Justice Cuevas sa manifestation niya kanina yung possible mistrial. Eh di ba dati niyo pa sinasabi na malayong senaryo yun?
Liliwanagin ko po yan ha. Makita niyo po, ang kagustuhan ni Justice Cuevas ay ituwid on kung ano ang mukhang medyo alanganin. Kasi ayaw niya nga umabot sa puntong ganoon. Because that is an option. Pero ayaw niya umabot doon. Sinasabi, because nasa batas yan eh. Ayaw nating umabot na magkaroon noon, kaya niya siguro pinaliliwanag yon. Ang kagustuhan niya is, Senator Judges, ito po ang observation namin sa mga panahon ngayon. Maaring hindi lang namin observation rin ng mga nanonood at ng ating mga kababayan. Pwede po ba liwanagin ninyo yung uri ng pagtatanong? Ano po ba ito, clarificatory? O pwede po ba kami mag-object? Because siyempre ang iniingatan niya ay ang karapatan ng Chief Justice. Liliwanagin po, wala po kami sinasabi na magmay-mistrial po kami. Hindi po. Ang sinasabi lang niya, para maiwasan ito. Kasi kahit po naman magkabilang parte, pag nakita nila na alanganin ito, pwede nilang hingin eh. Ito po ay hiningi na, ay sinabi namin, upang hindi tayo umabot sa mistrial. Well, sige.
Actually, wala tayong technically mistrial sa ilalim ng ating batas. Ito isang concept na nasa Estados Unidos kasi meron silang jury system. So, may mga factors na tinatawag nila pwede magkaroon ng mistrial such as, kunwari, yung meron mga jury na nagdesisyon na ayon sa kanilang personal interest or pag may problema dun sa indictment. Ang indictment, ibang-iba yan. Nandun yan sa Estados Unidos lang may ganyan. Sa atin, ang pwede talagang pasukan ng parang concept ng mistrial, which means na merong naging invalid yung proceeding because of a basic defect or a fundamental defect. Ang kapareho sa atin yan na pinakamalapit ng kapareho ay ang petition, yung certiorari nga, yung grave abuse of discretion amounting to lack or excess of jurisdiction. Kaya kung maalala ninyo, noong umpisa pa lamang, yung pagka merong mga instances na palagay namin ay magkakaroon ng nullity itong proceedings or pagkakamali dito sa proceedings, riniraise agad ito sa impeachment court kasi ayaw nga namin magkaroon ng nullity or yung pareho na rin ng mistrial. Kaya noong umpisa humingi na nag-file na ng motion for preliminary hearing nung tinatanong kung valid ba yung complaint na na-file ng mga kongresista dito sa impeachment. At yan din yung parehong tanong na dinulong sa Korte Suprema. Kaya makikita nyo, this was done in good faith na nasa umpisa pa lang tayo ng trial, gusto na namin ipasettle yung issue kung valid ba o hindi itong proceedings natin given this specific type of complaint na mukhang invalid. And at least pag masettle nila yan, alam natin na kung sa kalagitnaan ng trial, sabihin ng Korte Suprema, hindi, valid naman yung complaint eh. So hindi makatanggap-tanggap yung petition for certiorari, then we know na pagka dumating sa desisyon, wala nang questionin dito. Hindi katulad nung pwede namang antayin matapos yung proceeding, tapos kung hindi pabor doon sa nasasaktan, saka na lang mag-claim ng grave abuse of discretion.
Sir, the prosecution has said that they will finish their presentation of evidence by March. So kung ano nala'y abutin na articles of impeachment, either 2 or 3 articles, from your end, how long will it take you to present your evidence?
Siyempre, kung hindi na nila pakikita, depende kung anong sasabihin nila doon sa article. Yung ba ibig sabihin nila, waive na? meaning hindi na nila sinusuportahan ang kanilang mga articles, kasi kung wine-wave na nila yon, ang tatayuan na lang nila yung mga article na napresenta nila. Iba ho kasi ang usapan na kung ang sasabihin nila, ay hindi lang kami magpipresenta ng ebidensya, pero hindi pa namin binabasura yung iba. Ibang usapan yon. So kung sasabihin nila na 3 lang ang pipresenta nila at binabasura nila lahat, ay mas maikli ho tayo. Ibig sabihin, 3 lamang rin ang haharapin namin. Siguro ho, kung ano yan, give or take, this is an estimate based on experience, depende sa takbo po nito, no? Siguro mabilis na mabilis sa 1 buwan at 1 buwang kalahati yan. Mabilis na yan at least, ha? Hindi namin
Mabilis na yan, sir.
mabilis na ho yun. Ayoko kasing, I would like to be very honest with you, ayaw namin na itali yung kamay namin dahil naalala nyo nung nagsimula ito, sabi ng prosecution, 3 linggo tapos sila eh. 1 buwan na ho mahigit, 1 article po tayo. Nung in-interview sila ng mga kalagitnaan, sinabi nila, sa 2 buwan, tapos na namin lahat yan. Nakaka-1 article pa rin ho tayo ngayon. Mahigit 1 buwan na. Hindi po namin sila sinisisi, ginagalang po natin. Pero ang reality po na isang kaso ay araw-araw pwedeng iba ang paraan. So, ayaw namin magkaroon ng parang babalikan nyo kami later on. Sinabi nyo, 1 buwan lang eh. Bakit umabot na kayo ng 2 buwan? Yun lang po ang gusto namin maging maliwanag.
Siguro dagdagan ko lang, no? Maliban kasi sa mga issues na nakalatag dun sa verified complaint, by experience, nakikita natin na minsan may mga sumasangasangang issues na yung mga senator judges gusto rin naman nilang pag-usapan. So, kung titingnan natin talaga yung trial dates dito, yung number of days na magpipresenta kami, we have to take that into consideration din, no? Kasi kahit kaya namin na, sabi nga ni Attorney Tranquil, ng 3 or 4 weeks to 6 weeks, no? Pero kung may mga issues na gusto pa tayong pag-usapan, and we have to take into consideration na 23 yung senator judges, no? Kasi ordinarily, kung isa lang yung judge, mas mabilis, ano? But dito, 23 yung senator judges, may 23 silang pananaw, may mga 23 silang interest na gusto rin nilang talakayin o tukuyin. So, kailangan natin i-adapt din yung number of hearing dates ng defense with that consideration.
If they'll be presenting only or tackling 3 articles of impeachment, will you be using the same number of witnesses? 29 pa rin ba?
Yes, depende. Mababawasan ng kaunti, depende kung anong article nga, di ba? Dahil ngayon, Article 2 sila, Article 3, at kung tama ang aming pagsunod, Article 7 ang susunod. Kung ganun po, kung titingnan ninyo yung aming sinubmit noon na list of witnesses, ano po, yun lang ang tukuyin ninyo. Yung numero na kung saan nakalista mga testigo, yun lang po yun. Yung the rest, mababawasan. That is on the pretext or on the premise po na ibabasura nila yung the rest of their articles. Yun po.
Nangyari po ngayon sa reaction ng presiding officer sa nangyari ngayong hapon, ano na kayang mangyayari o sa proof beyond reasonable doubt na pinagmamalaki ni Congressman Tupas?
Alam niyo po, yung unang tinanong sa akin yan, kasi lumabas po yan sa periodiko, no? Na sabi nila, mapapatunayan nilang proof beyond reasonable doubt. Ang una ko pong reaksyon, bago ko sagutin yung katanungan na ito, ay ito. I welcome that declaration ng ating mga prosecutors. Bakit? Dahil ni-recognize nila yung posisyon namin na it's proof beyond reasonable doubt. Sabi naman nila, kayang-kaya namin patunayan eh. Hindi nila kailangan ng substantial evidence. Hindi nila kailangan ng preponderance of evidence. Kasi sinabi nila, at this point in time, although conclusion po nila yan, ano? At this point in time, it's already proof beyond reasonable doubt. Kami naman po, ang paliwanag po namin ay una, kung proof beyond reasonable doubt, tanong lang pong iiwan namin sa inyo, hindi namin pupunta ng merito ng kaso. Sabi po nila 45. Ilan po ang napatunayan nila? Or ilan ang nilista nila? At minarkahan, sabi nila 20 plus. Tapos ilan pa po doon, parking lot, at ilan pa po doon, questionable kung sino may-ari. Pero ilan po ang sinasabi namin? 5 lang. Okay, patutunayan po namin yan sa panahon namin. Sabi nila, napakadaming bank account. Sang katutak ito? Ang pinagmula po ng bank account na yan ay isang dokumento na questionable. Na maalala nyo, si Senator Miriam may nagsabi kanina, falsus in uno, falsus in omnibus. Ibig sabihin, kung may falsity sa iisa, falsity sa lahat. Kung ang tinatayuan nila ay ang dokumento na inattach nila sa application nila, na ang ibig sabihin po nito ay questionable ang pinagmulan, ang ibig sabihin lang po nito, lahat ay babaksak. Hindi po dahil sa may tinatago kami, liliwanagin ko po ito, no? Ang hindi po kami tinatago at itong nagangyayaring proseso na po, sana wag naman kaming sisihin na sasabihin, technical na naman yan. Kami daw po ang nagde-delay. Hindi po. Tingnan nyo po, ang may inherent na problema ay ang complaint po. So makikita nyo po yung mga markahan nila, sa patingin po namin, kung hindi po nila mapapaliwanag yung sinasabing either leaked document, fake document, or from a small lady, or yung iniwan po sa gate, kayo na po ang maghusgad yan. Kasi po, andyan naman yan eh. Mahirap naman sabihin namin, hindi, mali po sila. Siguro po kayo na maghusgad yan.
Well, sagutin ko. Siguro, hindi naman appropriate yung confidence. Siguro, mas appropriate yung with guided optimism. Nakikita namin na pagdating na ng panahon namin na maglalatag kami ng aming ebidensya para mapakita na walang katotohanan at wala namang sustansya ang lahat ng bintang labang kay Chief Justice Corona, kumbaga mas maganda na yung arangkada namin. No? Mas maganda na yung dating ba. No? But, kung yung confidence, napakaaga, no? Pati hindi naman kasi ito palakasan ng loob. Palakasan to ng ebidensya, palakasan to ng argumento, at palakasan to talaga ng pagpapaliwanag sa mga senator, judges, pati sa publiko na rin.
Sir, Geoffrey Cagape from Bomboradyo. Would you consider na itong pagbabawas ng artikulo ng prosecution ay dahil sa kakulangan ng ebidensya at sustansya sa artikulong laban kay Chief Justice Corona?
Well, kasi alam niyo po, napakahirap pangunahan ng prosecution sapagkat sila ho talaga ang merong determination, no? At sila ho ang merong discretion kung paano nila pipresenta yung kaso nila. Simulat sa pulpo, hindi kami nagkukomento kung tama ba o mali ang ginagawa nila. Sapagkat kami po sa depensa, nirirespeto po namin ang kakayahan nila, ang diskarte ho nila dito sa kaso nila. Para naman po pagdating ng pagkakataon namin na kami naman ang maglalatag ng ebidensya, mapapakita rin naman po namin kung paano po ang aming approach dito sa kasong ito.
Ayun sir, elaboration lang po dun sa Ramos versus People of 2010. So ano po ba yung naging verdict nito at yung connection sa case ng defense?
Sino nag-cite nun?
Si Senator Santiago.
Under what premise? Ito yung sa, naalala ko na ito.
RPC.
Oo,
171.
yung sa ebidensya. Okay. Ang tinutukoy po niya dito yung sa kaso ng falsification, ano po. Very simple lang naman po ang tinutukoy ng ating Senator Judge. Kung ang naging ugat, okay, na ebidensya, ay hindi dapat pagbatayan, yung mga susundan po nito ay hindi na dapat natin asahan. And napakaliwanag po ang paliwanag dito. Yes.
Ayun po sir, tapos para sa kaalaman ng ating mga kababayan, meron palang malaking pinagkaibang falsification at forgery. Yung delineating line na lang po between those terms.
Okay. Ganito po yon. Pag falsification kasi, pwede po na wala yung tao doon pero pinalabas niya na nandun siya. Meron din po na nagkaroon siya ng insertion or intercalation na sinasabi niya na may mga pagbabago na ginawa sa dokumento na pinalalabas o pinapass-on po itong totoo. Falsification po yon. Yung forgery po ay natutukoy yan generally dun sa handwriting na pinalalabas, ipinapass on na ito ay sulat or pirma ng isang tao pero ang katotohanan ay hindi naman. Yun po. May katanungan pa po? Okay, hintayin po natin susunod. Meron po siyang natanggap ng mga benepisyo. Ganun kasimple. Kaya hindi namin maintindihan kung bakit ayaw ilabas o ipalabas ng...
Good afternoon, Mr. President.
Yes.
Can we just be allowed to make a short manifestation, Mr. President?
Proceed.
Thank you so much. Mr. President, this is regarding the exclusion of the testimony of the witness from the Philippine Airlines. With the utmost respect to the Honorable Presiding Officer, the prosecution takes exception to the ruling regarding the matter, and it is the position of the prosecution that with the presentation of the witness from PAL, the prosecution does not expand the complaint as stated.
Why not?
For the following reasons, Mr. President. As to the relevancy to the Article 3, it proves consideration, inducement, motive. To us, the motive here is very, very important, crucial, critical to an impeachment proceeding. The motive for what? The motive for the Chief Justice in flip-flopping. The motive why the Chief Justice acted on a mere letter based on paragraph 3.3 of the article. The motive why the Chief Justice involved in the administrative matters that are alleged. So we allege here the flip-flopping, Your Honor. We allege the mere acting on a letter by Attorney Mendoza. But to us, it is very important to prove the motive in an impeachment
You should
proceeding.
have alleged bribery. If you understand the meaning of bribery.
Yes, we did not allege that, Your Honor.
Precisely, but that is the tendency of the evidence that you are presenting.
But, Your Honor, the very heart of Article 3 is integrity, providence, and independence.
Correct.
Probity.
Correct, but you limited your charge for lack of competence, probity, and integrity in 3 ways. Mr. Counsel, I do not know how you learned your art of pleading. I do not fault you, but I'm basing my ruling on your allegations and nothing more. And if you are going to insist on your position, I say I will not change the ruling.
We respect that, Your Honor. Can I just finish my manifestation?
Now,
With the utmost
want me
respect.
to order you to amend your articles of impeachment and send it back to the House?
We wouldn't, no, Your Honor.
You have a choice.
We respect that, Your Honor. But it is, I just want to finish, Your Honor, that
Yes.
technicalities cannot be permitted to prevail in such an important proceeding.
This is
such
not
as,
a technique,
such as,
for heaven's
this
sake, this
impeachment
is not
proceeding.
a technicality. The grounds for impeachment are very clearly stated in Articles 11 of the Constitution. We are already very liberal. You're in effect asking us to review the decisions of the Supreme Court. Who are we to review the decisions of the Supreme Court? But do you allow it in order not to embarrass you? But you are going too far.
We respect, of course, we have a very high respect.
Do you want me to lecture to you more?
No need, Mr. Presiding Officer. Anyway, Your Honor, that is we just want to put that on record as the position of the prosecution.
Well, I
That's
will
all.
tell you, if you want to allege the receipt of gifts, the receipt of valuable things by the respondent, then amend your articles of impeachment because you are in effect alleging a crime, which we will have to evaluate whether it is a high crime. You are in effect alleging that he was bribed to make that decision.
Yeah, but Your Honor, the charge here, the ground is betrayal of public trust. Anyway, Your Honor, thank you for that, for giving us opportunity just to, we just want to thank the Honorable Presiding Officer for giving us that opportunity just to state for the record the position of the prosecution of the matter. And now, may we request that one of our private prosecutors be recognized again. Attorney Marlon Manuel.
Attorney Marlon
Manuel, Your Honor.
Manuel.
Thank you.
Proceed.
Thank you, Your Honor. We will make a tender of excluded evidence, Your Honor, under Rule 132 of the Rules of Court. And we would like to state for the record that if had PAL Vice President for Sales, Enrique Javier, been allowed to testify, he would present the following documents, which were required to be submitted pursuant to the subpoena that was issued. First, Your Honor, and this was previously marked as Exhibit Septupol P, this is a certification and compliance signed by Enrique P. Javier, saying that Platinum Card number A752 was issued in the name of Corona Renato C. The date of issuance is December 2010, and the expiry date is December 2011.
Your Honor, please.
Well, wait a minute. I will allow the manifestation. What is the pleasure of the...
Yes, Your Honor. Thank you very much, Your Honor.
Well, practically, this is adducing evidence through a manifestation, Your Honor.
This is a tender of excluded evidence, Your Honor.
The proper of evidence, Your Honor, is proper only when there is a witness on the stand and a question had been propounded to him, thereby, and an objection is made, thereby sustaining the objection, so that if the witness was not prohibited from further testifying, then the counsel, his counsel, or the counsel conducting the examination may make a proper of evidence. That is the situation where that rule applies, Your Honor.
Your Honor, may we allowed to respond?
Yes.
Under Rule 132, Section 40, if the evidence excluded is oral, the offerer may state for the record the name and other personal circumstances of the witness and the substance of the proposed testimony. So this is precisely the situation that we have now.
Your Honor, please.
We have discharged the witness.
Yes, Your Honor. That is why we are making the manifestation for the record on the substance of the testimony of the witness.
This is if Your Honor, please, this is unprocedural. This is violative of the cardinal rules on evidence, Your Honor. As we have stated, that can be done only when there is a witness on the stand, there is an objection, and the objection is sustained. So there could be a proper of evidence.
Anyway, counsel, even if I allow the matter to remain in the record, it is to me it's not evidence yet. So let it be.
Thank you, Your Honor. Your Honor, based
what
on...
is a platinum? I don't understand what is a platinum.
Yes, Your Honor. A platinum
What is-
card, Your
No,
Honor.
you cannot state it for yourself.
I am not stating it,
You're
Your Honor.
not under oath.
Yes, Your Honor. But I am referring to a record showing the benefits of a PAL platinum card. And this is based on the
Counsel.
certification.
That is improper for counsel to state. You should have presented a witness for that purpose.
Your Honor, I am referring to an annex of the certification of the witness. This was already marked, Your Honor.
Let it stay as it is. The ruling of the chair stays.
So may we be allowed to continue with the manifestation, Your Honor? The PAL Platinum card was used based on the certification and compliance for 4 round-trip travels. 1, Manila, Guam, Guam, Manila, dated April 20 and April 24, 2011, respectively. Manila, Singapore, Singapore, Manila, April 15, 2011 and April 19, 2011, respectively. Manila, Honolulu, and Honolulu, Manila, December 25, 2010, and December 30, 2010, respectively. Manila, Hong Kong, and Hong Kong, Manila, December 18, 2010, and December 21, 2010, respectively. And then the platinum card number A753 in the name of Corona Maria Cristina R. Date issued December 2010, expiry date December 2011. And there are 12 round-trip travels recorded in the certification and compliance. Manila, Jakarta, Jakarta, Manila, July 10, 2011, and July 15, 2011, respectively. Manila, Guam, and Guam, Manila, April 20, 2011, and April 24, 2011, respectively. Manila, Singapore, and Singapore, Manila, April 15, 2011, and April 19, 2011, respectively. Manila, Bangkok, and Bangkok, Manila, March 4, 2011, and March 7, 2011, respectively. Manila, Honolulu, and Honolulu, Manila, December 25, 2010, and December 30, 2010, respectively. Manila, Hong Kong, Hong Kong, Manila, December 18, 2010, and December 21, 2010, respectively. Manila, Bacolod, Bacolod, Manila, July 28, 2011, and July 28, 2011, same dates. Manila, General Santos, and General Santos, Manila, June 3, 2011, and June 4, 2011, respectively. Manila, Cebu, and Cebu, Manila, March 18, 2011, and March 19, 2011, respectively. Manila, Tagbilaran, and Tagbilaran, Manila, March 22, 2011, and March 24, 2011. Manila, General Santos, and General Santos, Manila, March 2, 2011, and March 3, 2011. Manila, Cebu, and Cebu, Manila, February 15, 2011, and February 16, 2011. Your Honor, Annex A of the certification and compliance refers to the benefits of the PAL Platinum card. And may I read for the record?
The document speaks for itself.
Yes, Your Honor.
All right.
Your Honor, in that case, may we make a manifestation
Yes,
that had...
Just present the evidence. You have already marked it as exhibit, you said, so be it.
This was marked as
The
septuple.
contents of the document is the best evidence. You cannot add anything to it.
Yes, Your Honor. Septuple P-4, Your Honor, is the passenger name record BZFUMN in the name of Corona Renato Mister, Corona Maria Cristina MS. Exhibit Septuple P-5, Corona, passenger name record CFFTE2, Corona Renato Mister. Septuple P-6, Corona Renato Mister, Corona Maria Cristina. Passenger name record C6QIWN. Exhibit Septuple P-7, passenger name record BKEHT6 in the name of Corona Renato and Corona Maria Cristina. Exhibit Septuple P-8, passenger record, name record EHIZDW in the name of Corona Maria Cristina, all with indications of business class and the use of the platinum card, Your Honor. We have also marked as exhibit Septuple P. Okay, Your Honor, those are referring only to the names in the passenger name record.
Are you true?
If Your Honor, please, if the...
Yes, Your Honor.
Just a minute. You're offering this under Article 3,
Yes, Your Honor.
but you have not alleged any bribery. Isn't it, under Article 3?
We have alleged...
No, you did not answer my question. You did not allege bribery.
Not bribery, Your
All
Honor.
right. Finished.
If Your Honor, please. On the part of the defense, Your Honor, we move to strike out any and all manifestations made together with the documents now marked as exhibits, Your Honor. And this is the purpose, Your Honor. This is allegedly offered pursuant to the rule on proper of evidence, Your Honor. We are in conformity with counsel that this may be done, but not in this particular situation, because here there is an allegation under the article of impeachment, and the evidence is being presented not in accord or to sustain that. There is nothing in the article of impeachment which will cover this particular matter, Your Honor. So the proper of evidence is highly improper and should be excluded at all costs, Your Honor. Because first, the manifestation was made not under oath. We cannot accept the veracity, authenticity, and accuracy of what is being introduced into the records. The manifestation was made by counsel. He is not under oath. He can be a witness if he wants to, Your Honor, so that we can cross-examine him. But this is not a case of not being able to answer a question because there was prohibition by the court. This is a case where there is an impeachment article and the evidence so to be presented is not embraced in that particular article. So this is decidedly illegal, Your Honor. It has no probative value whatsoever.
Anyway,
Thank you, Your
Counsel,
Honor.
Counsel, I think you and I understand that this evidence is nothing because
Thank you, Your Honor.
it assumes something that is not established yet. So let it remain in as a manifestation of counsel, and it will be appreciated by the members in whatever they wish. But we will discuss this in due time.
Thank you, Your Honor.
You know, with due respect to the members of the prosecution panel, this presiding chair has been very lenient. I tried to help you. But there is a limit to what this presiding officer can do. If your articles of impeachment are defective, that's your responsibility. You made an allegation, a specific allegation, charging the respondent with lack of probity, integrity, and so forth and so on. And you stated the basis of your conclusion. Your statement that he does not have competence, probity, integrity, and what else?
Independence.
And independence is a conclusion of fact based on what you want to prove. And now you're offering a stranger in paradise to prove an allegation that does not exist in Article 3. That's why I consider this a trust. So let it be a part of your manifestation if you want to. Proceed. Next witness. You present your next witness.
Yeah, Mr. President, just 1 minute recess, please.
Okay, 2-minute recess.
Thank you.
flip-flopping pertains to the PAL FASAP case. Would you...
resolution, yung administrative function ng Supreme Court, sinabi nila, we're setting it aside. So effectively, the Supreme Court acted on a mere letter. Hindi, pag sinasabi namin mere letter, several times sumulat ang PAL-FASAP, yung mga Flight Attendants Union, sumusulat, no, nagsasabi, pwede bang paki-expedite? Marami na sa mga kasama naming namatay, marami na dito hindi may padalang kanilang mga anak sa paaralan. Pwede bang bilisan na po ng Korte Suprema? Ano ang sinasabi ng Korte Suprema parate? 3 times, sabi ng Supreme Court, please do not write us without furnishing the adverse party a copy of your letter. Pinagagalitan effectively ang Flight Attendants Union. Pero bakit nung sumulat si Estelito Mendoza ng 4 na letters in a span of 48 hours, biglang isinantabi nila yung desisyon na final na. This witness will show not a new act. He will not talk about a new allegation. This witness will simply say, ito po ang dahilan kung bakit violate ni Chief Justice yung basic virtues of integrity, probity, and independence, kung bakit niya inaksyonan yung mere letter na kung noon hindi nila pinapayagan, bakit nila pinayagan dito bigla? Yung witness na ito magpapaliwanag kung bakit pabago-bago yung desisyon ng Korte Suprema pagdating sa PAL-FASAP. Hindi ito allegation of bribery. It was just going to allege that the Chief Justice was a recipient of a platinum card. Ano ibig sabihin ng platinum card? Sinabi na po, nandun naman po sa dokumento, na ang isang platinum card holder ay ibinibigay ng korporasyon ng PAL sa iyo. Ano ang benepisyo? Ang benepisyo ay free travel anytime in the highest class available. Hindi mo kailangan ng ticket.
Your Honor. Until tomorrow?
Tomorrow, Your Honor.
Well,
2 o'clock, Your Honor.
Well, I would like to explain to the public that the discharge of your witness, because his testimony was considered irrelevant with respect to the allegations of Article 3, is not the fault of this court. It was the fault of your way of presenting your case and in making your allegations in your articles of impeachment. Okay? Yes, sir. The requested continuance is approved.
Mr. President.
Majority Floor Leader.
Yes, Mr. President, we are in receipt of the explanation of votes of Senator Pimentel and Senator Pangilinan. I move that we include it in the record of the impeachment court.
Let those explanation of votes be included.
May we ask the Sergeant at Arms to make an announcement, Mr. President?
Please all rise. All persons are commanded to remain in their places until the Senate President and the Senators have left the session hall.
Mr. President, I move that we adjourn until 2 o'clock in the afternoon of Wednesday, February 22, 2012.
Any objection? Hearing none, the trial is adjourned until 2 o'clock in the afternoon of Wednesday, February 22nd, 2012.
Time throughout the year in the highest class possible. So kung merong first class ng isang biyahe, may business class, doon sila. So the Chief Justice traveled 4 times in a matter of just 6 months or 7 months during a time when the Supreme Court set aside. Remember, the Supreme Court set aside the decision on that mere letter by the Council of PAL. They set it aside October 4 of 2011. So during that time, he was already in effect a platinum card member. And in fact, a few months before that, he had already benefited all the way up to the month of April sa mga libreng biyahe. Sinabi rin kanina ng testigo that there were 12 round-trip tickets, including international trips ni Mrs. Corona using this particular benefit.
Okay, sir, the impeachment court seems to have ruled out this particular evidence for now. And they just moved for a continuance, and which was granted by the court. Wala na kayong ibang witness aside from the PAL person for today. So what's going to happen now? Sino iuupo niyo witness bukas?
There's may subpoena for Secretary Laila De Lima. That's dated February 22, which is tomorrow, Wednesday. So we're expecting na darating po siya at testigo po siya. So we'll be ready to present her po bukas.
This is for Article 7?
Yes. For Article
Aside from Secretary De Lima, who else are you presenting? Yung confirm na mape-present ninyo?
Wag na muna siguro, RG, kasi anyway, nandun yung compliance natin, but we don't want to telegraph our punches.
At least for tomorrow. At least for tomorrow.
Well, definitely Secretary De Lima because may subpoena nang na-issue sa kanya, no? But
just De Lima for tomorrow?
Yeah. I'm sure we'll have other witnesses ready, no?
Let's also put on record that we had other witnesses for Article 3 that were in fact ready, particularly those that were supposed to be presented by Congressman Fariñas. But the decision on the PAL Platinum card struck us like lightning today that in effect cascaded down to the 2 other witnesses aside from the PAL Vice President. Meron pa tayong ibang mga testigo pertaining to Article 3, pero kung dun mismo sa PAL, which is absolutely in point, ay hindi ho nila pinahintulutan na tingin namin kinakailangan ho namin iapila dahil sa tingin namin hindi tama ang desisyon doon. Yung iba pang testigo ay inantay. We made a decision that if the court was not going to reconsider that decision, we will hold in abeyance those other witnesses because obviously we will get the same ruling for those two other witnesses pertaining to Article 3. Nandun na sa, it's part of the compliance, pero wag na muna natin identify. You know, the subpoena was issued by the court, and the reason for the issuance of the subpoena was told to the court. There was a motion to quash filed by the defense. Nag-file po ang motion to quash ang defense pagdating dito sa PAL witness natin, pati sa subpoena. And no action was done. So effectively, pinayagan po natin yon. But once again, we see that the defense objecting on this matter, completely are resorting again to technicalities to prevent us from presenting these witnesses. Parang in the end, parang are we better off talking about these things outside or in the court? Aren't we better off having a more liberal acceptance of evidence and let the court decide later on as to which evidence will be acceptable, and then at the same time, let the court weigh it. Timbangin nila later on kung alin ang mabigat na ebidensya. But in this case, sa unang bugso pa lang na hindi kaagad pinapayagan, parang tila hindi ho namin talaga matanggap.
At nagtataka kami kung bakit biglang naging stricto dito ang impeachment court sa Article 3 sapagkat soon sa Article 2, kung babasahin nyo naman ho yung reklamo, hindi naman ho nakabanggit dun yung Belacio. Belacio nakabanggit pala. Yung Bonnie Ridge, hindi naman ho nakabanggit dun sa reklamo. Yung columns, hindi rin nakabanggit. Yung mga bank accounts, hindi naman nakaisa-isa po yun. And yet, we were allowed na magpresenta po kami ng ebidensya po doon sapagkat nakita ng korte na siya ay relevant o mahalaga para ipakita po yung kawalan o yung pagtataksil ng tiwala ni Chief Justice. Dito naman sa Article 3, pareho po yung alegasyon namin na nagtaksil po siya ng tiwala ng publiko sa pamamagitan ng mga akto na ginawa niya na nagpapakita ng kawalan ng integridad, katapatan, at may kinikilingan siya. So nagpe-present ho tayo ng additional evidence just to prove this point ho. Yung pagpe-present po dun sa mga PAL tickets at sa benefits na nakuha sa PAL ay to support the allegations na naging partial siya po dun sa PAL. Doon naman sa Article 2, di naman natin i-allege isa-isa po yung properties niya, and yet we were allowed to present in support of non-disclosure. Nagtataka po kami, bakit dito sa Article 3, hindi kami pinayagan to present evidence in support of lack of integrity po. Yun ang siguro nakakapagtaka, kaya nagulat ho kami dito dahil sa amin ho, at siguro pag tinanong namin sa inyo, sasabihin nyo rin po, ay mukha namang relevant ata yung pagtanggap niya ng benepisyo sa isang korporasyon na may kaso sa harapan ng Korte Suprema at pabago-bago yung desisyon. So siguro, klarong-klaro naman ho siguro kay Juan de la Cruz o sa lahat ng nanonood dito kung ano po yung relasyon ng pagtanggap ng benepisyo ni Chief Justice at dun sa kanyang naging desisyon sa PAL case.
So hindi po ba kaya yun yung punto ni JP kanina when he mentioned na liberal na sila in the past, tapos parang hindi pa rin natuto yung prosecution?
Yun nga ang point namin why not be consistent ho sa ating mga rulings? Kasi in a murder case ho, for example, ang meron tayong information, isang sheet of paper lang ho yun on the day of ganito, December 20, 1935, the accused so-and-so in the vicinity of so-and-so did feloniously stab so-and-so. Pero yung motibo, tatanggapin po ng korte yon. So, isinasabi po natin, kung sa criminal case po, na mas stricto po ang rules of evidence, tinatanggap po yung ebidensya ng motibo, bakit ho dito sa impeachment, hindi po tinatanggap yung ebidensya tungkol sa motibo? Di ba dapat mas maluwag ho tayo sa impeachment case?
Sir, balikan na natin yung mga witnesses. Is Mr. Lauro Visconde one of the other witnesses na represent nyo dapat?
We'll answer that once we're able to get a definitive strategy on this PAL case muna, no? Kasi tingin namin this is very, very critical because very, very important. Because linawin lang po natin, Paulit-ulit. In fact, sinabi namin, we are not alleging bribery. We are simply alleging that based on the allegation doon sa ating impeachment complaint that he set aside yung desisyon ng Philippine Airlines, inaksyonan po nila yung mere letter lang po in violation of the internal rules of the Supreme Court, in violation of the due process rights of 1,780 flight attendants of Philippine Airlines. At gusto po namin sabihin sa testigong yon na ito po ang dahilan. So, pag sinabi po ni Congressman Sani Angara kanina, in a murder information, you just put all the specific allegations. I mean, all the ultimate facts sa information. Pero dun sa trial, ipapaliwanag mo ano yung dahilan kung bakit niya gustong o bakit meron siyang intensyon na patayin ito. You don't put that in the complaint. And it's not a new charge. This witness was actually going to say that these are the very reasons why the Chief Justice was induced in acting that way. I'd like to turn over to...
Dagdag lang sa sinabi po ni Miro kanina, hindi lamang travel courtesy ang binibigay ng Philippine Airlines. Applicable taxes, fees, fuel and insurance surcharges are waived courtesy of Philippine Airlines. No? So, taxes, ayan, binabayad sa ating gobyerno yan. No? So,
Sir, I'm just curious, bakit hindi ninyo na lang inallege yung bribery to begin with?
Because it's not, it's
not bribery?
Well, it could be. But, you know, you have to remember that the original complainants here were the PAL flight attendants. Diba? Malinaw yun na sila yung nagreklamo nung una. In fact, we've had several hearings on this matter. And Article 3 specifically talked about how unstable and flip-flopping the decision of the Supreme Court was, not only with the PAL-FASAB flight, but as well as with the League of Cities. Ibig sabihin, tinitingnan natin ano yung motibasyon kung bakit nagbabago-bago. At ito yung dahilan kung sa tingin namin kung bakit ay siniset aside at iniisang tabi lamang ng ganun kasimple on the part of the Chief Justice. Now, this is purely evidentiary. It's not an allegation. It's not a new act upon which we want him impeached. This is the very reason that impelled him to act that way, na nagtulak sa kanya para kampihan niya ang Philippine Airlines. Yun yung sinasabi namin sa aming alegasyon. Unlimited courtesy travel ng Philippine Airlines on the highest class of service. Sinabi ni Erin, applicable taxes, fees, fuel, and insurance surcharges are waived courtesy of Philippine Airlines. Yung free baggage allowance, kung sa usually isa o dalawa, sa kanila 23 kilos each. Ang dami yung benepisyo na binibigay sa kanila, not because it's given because of their frequent traveling, simply because he was obviously the Chief Justice.
Dagdag lang sa tanong po ni RG, maski hindi po namin i-allege yung bribery, doesn't mean na hindi pwedeng pumasok sa betrayal of public trust ito. At yun po yung gusto po namin na pinapaabot parati na hindi nga ito dagdag No? Kung sa tingin po ng ating presiding officer at na ito ay dagdag na allegation dahil bribery, hindi namin sinasabi na bribery. Sinasabi pa rin namin betrayal of public trust ito. Kaya walang pagbabago.
We'll cross Article 3, the Article 3 bridge when we get there, no? I think pag-uusapan namin ngayon, at titingnan natin ano yung ating mga remedies. Malinaw para sa amin na importante yung ebidensya na dapat presenta ng Philippine Airlines dahil makakapagpalinaw kung bakit ganun-ganun na lamang ang action on the part of the Supreme Court. So, we don't want to answer that. We will talk about it this afternoon on what we should do considering this very surprising matter with the Philippine Airlines.
Kung mapilitan po namin yung impeachment tribunal, baka may pabalik, no? Depende nga natin. Well, titignan natin.
Alam mo, yung prisoner's dilemma namin dyan is, yung dilemma namin is hindi kami tulad ng defense eh. May takbuhan sila yung Supreme Court, no? Na kapag di sila nakakuha ng solusyon dito, ay may tinatakbuhan silang sariling tahanan. Kaya nila mamangka sa dalawang ilog, kami hanggang isa lang talaga. Ito yung sinumpaan namin. We really don't have any choice. And that's what the Constitution provides. But we will see what the available remedies are. We have to reassess. This is a very important point.
Sir, don't you have the president?
I'm sorry?
Don't you have the recourse of asking the political assistance of the president?
What can the president do? The president has, ironically, in this case, it is the Chief Justice and the Supreme Court who can overrule everybody if we were to follow their logic and if we were to follow the Constitution. In the end, with the vast powers of the Supreme Court, they are ultimately becoming the most powerful and most entrenched branch in government. The president cannot even outrule them. I mean, pag nag-decide the Supreme Court, nobody else can. And right now, we've always been telling the Senate Impeachment Court that you are the highest and only constitutional court established for this particular undertaking. You cannot surrender it. And in as much as we'd want to go to the Supreme Court, we also don't want to abandon that philosophy that the decisions of the Senate Impeachment Court are final and unappealable. Meron pa, pero we need to be able to assess considering nga itong ruling na ito. Para sa amin, mabigat yung naging ruling sa araw na ito which requires us to reassess. Kung tayo lang sana, hindi ko nasasabihin, ano? Pero antayin na lang po natin. Let's deal first with this dilemma or this problem that we have with the Philippine Airlines free tickets. Nasabi na po ni ang nakaslate natin dyan is alam naman ng lahat for Article 7 is si Secretary De Lima, pero abangan natin muna.
Hindi pa rin.
We will see this afternoon. We will see kung anong mapagkakasunduan po namin. Ano po?
Are you prepared to say na the impeachment court is also flip-flop? Because that's what you said. No, be frank.
You know, the big difference with the impeachment court and the Supreme Court is that the impeachment court is a political court. It is a constitutionally created court, and by design, nilagay dyan are elected officials, meaning they can't make mistakes. End of the day, the Senate Impeachment Court cannot make mistakes because they are the nationally elected officials. That's why the Constitution placed it there. Hindi siya nilagay sa Korte Suprema, hindi siya nilagay sa isang select number of justices coming from the Court of Appeals, Supreme Court, RTC. Hindi ganon. Nilagay po yun doon because precisely the activity is a political exercise. And we've always taken that position in spite of the fact that the defense has always been saying that everything is reviewable by the Supreme Court. So if you're asking us if it's flip-flopping, the Senate Impeachment Court is free to make its own decisions. It is not bound by jurisprudence. The only thing that it is bound to is due process and fairness. And today, I think parang kailangan po namin pag-usapan kung if the decision today was actually fair, not only for the prosecution, not only for the people, but for the 1,780 PAL flight attendants who up to today, after 14 years, have not received the justice that they have been asking for from the Supreme Court.
I think yung mahalagang stress in relation to the decisions of the impeachment court, Cynthia, pag in-exclude mo na yung ebidensya, there's no way of considering it anymore. So dapat that's one area where yung admissibility of evidence, where we should be particular, very particular about. We should be very consistent on. Kasi pag in-exclude mo na yon, hindi mo na pwedeng i-admit yon. Pero yung vice versa, it's not true. Kasi pag in-admit mo, you can still exclude it later on. The judges, pwede nilang sabihin, ay, hindi importante to, huwag na natin pakinggan ito. Pero once in-exclude mo na, pinawalang bisa mo na yan, you can no longer admit it
Sir, nag-flip-flop nga